Hey everyone. So there has been so much change in US immigration in just 1 month. Yes, we are only 1 month into the Trump administration, and there has been a lot of changes. I prepared this live a couple like a day ago. And yesterday I had to add things to what I was going to talk about today because there's just been so much change in just one day. So from yesterday to today, there's been change, and I had to like the things that I'm going to talk about on this is going to be more than what I planned initially. So bear with me. It's a lot of information coming out. If you are joining me live, feel free to say hi. Tell me where you're joining me from. And if you have questions, make sure to put them in the comments. If you're watching this on the replay and you have questions, put them in the comments as well. If you do not already know me, well, thank you for coming. First of all, I am attorney Lillian Chukura. I'm a US based immigration lawyer, and I help my clients get green cards and citizenships using the US immigration law system. As much as it's changing right now, we are still able to make that happen for our clients. So we will continue working with the US immigration system that we have. And it's getting harder. I will tell you that. It is getting harder. However, we're here and we're gonna keep doing the work. All right. So remember, questions, put them in the comments. Let's jump right in. The first thing, if you have TPS and you're from Venezuela or Haiti, I am so sorry, but they have vacated the TPS extension. So there's the designation, and then they extended that designation so that you can reapply for TPS. That is going away. So when your current TPS expires, that is it. And for most of those countries, it's going to expire this year, if not next year. So it's really important to know that and then figure out what your next steps are going to be and plan ahead. Remember, when I do these videos, when we were talking before the new administration started, I made sure to let you know that your first step is to figure out what you qualify for and start working on it, because that's what's going to really make a difference for you, is if you already know what you qualify for and if you start working on it. So this is really going to push a lot of people to start taking action. So TPS for Venezuela and Haiti are now, once the current one expires, that is it. It's not going to get renewed. It's not going to get redesignated. None of that. It is gone, at least with this administration. Okay. Another update we got this week is that the people that entered the US with U4U, so Ukrainians that entered with parole, Haitians, Nicaraguans, that Cubans, right, Venezuelans that entered with the parole program, they are now facing an additional hurdle, because if you enter without parole and you have a US citizen spouse eventually, or a child that wants to file for you, you are able to adjust your status in the US. You are able to apply for TPS if you were in the US in time to apply for TPS. There may be other applications you qualify for, and you're able to apply for those. Well, now what we're dealing with is that there's a new guidance that basically put a pause on any applications filed by people that entered under any of those Biden administration programs. So if you entered under the, parole program for Haiti, for example, and you now are married to a US citizen and they're filing for you to get your green card, that application can be paused. And they're saying they're pausing this because they want to review that parole program, the people that entered through it, to see if there was fraud. Again, this is all ways to stop people from gaining status in the US. It's not really keeping people out of the US. So It's one of those things that when we talk about legal immigration, you have to remember that these people entered the US, followed a process that was created by the US government that would allow them to come to the US with documentation, right? Parole is you having permission to enter the US. And now they're basically saying, even though we preach that you should come to the US the right way, and you did come to the US the right way, following US laws, you are now not able to adjust your status, change your status, do any of that because we think you shouldn't have gotten it in the first place and they may be fraud. Someone out there may have committed fraud. So now we're going to punish you for it. So those applications are being put on hold. So if you already have an application pending and you don't hear anything anytime soon, just know it's probably because of that pause. Okay. And then one big one for people that are already in the US that, had a conditional residency. This is a big one. If you have conditional residency, an I-751 application was filed and that application was denied and you were referred to immigration court and you have immigration court proceedings, you should not travel outside of the US. So even though you're able to get your ADIT stamp showing that you are still a permanent resident until a judge says otherwise, what we're seeing at airports and what we're getting confirmation from CBP on is that if you are a conditional resident, your application to remove those conditions were denied, and then you're put in immigration court proceedings. If you travel outside of the US, the new policy is for them not to let you back into the US. So if you're in that situation, do not travel. Usually I don't have like a blanket, like don't travel thing, but this is one of those where we have actual confirmation. So do not travel because you may not be able to come back into the US. And they are not listening to anyone about that. So make sure that you are following the guidelines that I'm giving you. Okay. This, talk to your lawyer, see what your position is. If you are in immigration court proceedings and you have that ADIT stamp, just know it's not going to be enough to bring you back into the US anymore. Before this policy change, you were still considered a permanent resident, which means you can travel in and out of the US without an issue. But now that policy has changed, so you need to protect yourself and make sure you remain in the US. If you're currently outside of the US and you're in that situation, contact your lawyer, make sure that they're prepared to assist you to return to the US. Really important here. All right, so I'm just gonna pause here because the next things are a bit depressing. So I'm going to pause and answer any questions. So if you have questions, feel free to put them in the comments. Right? Damien, hi. So when paying for marriage green card package filing fee, when using cashier check, should it be separate check for each application or one cashier check in total, or should I use money order? It doesn't really matter whether it's a money order or a cashier's check. You just need to make sure it's made out to the right people, right? U.S. Department of Homeland Security, not DHS, not USDHS, okay? It needs to be made out to the right organization. So U.S. Department of Homeland Security. Do you need separate checks? You can choose to do separate checks. The reason that in my office we do separate checks is if one application is rejected. So let's say you file in your I-130 and your I-485, right? And you did one check for both applications. If the I-485 is rejected, they also have to reject the I-130 because you only gave them one fee. However, if they're separate fees, they can process the I-130 and just reject the I-485. So it's really, that's why we do it in my office. You can do it however you want, but how we do it is separate checks for each form in case, right? In case the worst case scenario happens and the application is rejected, we want them to still be able to process some of the forms, right? So an I-130 can be processed without an I-485. So if that situation happens where the I-485 is rejected, you want to make sure your I-130 can still be filed because you put in the separate checks. They can go ahead and separate the applications. So that's why I would recommend separate checks. But whether you're doing cashier check or money order, doesn't really matter. You just need to be able to, one thing I do recommend is being able to track it. So typically with a cashier's check, it's not easily trackable, right? A money order, you have a receipt, you can check if it's been cashed or not. A cashier's check, it's really harder to track. So that may be a reason to go with the money order versus the cashier's check. Okay. So Sabrina99 on Instagram. If you can just give me more detail on what you're asking, I may be able to give you more information. Your question is not really clear to me. All right. Okay. So, like I said, the next part of the things that are happening are going to be a little more depressing, but it's information that you need because you need to know how to navigate the US, right? You don't want to, like, you know, la 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 all over the place, right? We want to have the information so that we know how to navigate our day-to-day lives. So here we go. The US, if you watch my video on mass deportation, right, I mentioned that there's ways to do mass deportation without actually doing mass deportation, right? Which is expedited removal. And I hoped that I was wrong, but it turns out I'm not wrong, right? Expedited removal has been expanded beyond what it was expanded a couple weeks ago, right? One of the first executive orders was expanding the places they can detain people based on expedited removal. Now that has been extended. All right. They have further extended who is subject to expedited removal. So it's really important that if you have ever had an ICE interaction, so if you were entering the US, you were detained by ICE and then you were released, most of the time when you are released, you are given a determination that you are inadmissible to the US. Those people that were given that determination, right? Either you entered the U.S. without a visa, you didn't have documentation when you came to the U.S. Those determinations, you're usually given a lot of ICE when you're released. If you have one of those, you are now subject to expedited removal, regardless of if you have been in the US for over 2 years. So that's why I said they are expanding expedited removal, who's subject to expedited removal exponentially beyond what it's typically used for. So we are going to be seeing people that were in, CBP custody, in ICE custody, and were released out of custody being re-detained, right? And being subject to expedited removal. This is a big, big change because typically when you are released from ICE custody and you have like an asylum application pending, you have a case or you have TPS, things like that, you're not typically subject to expedited removal. And when it comes to when it comes to people that are in a situation that you are subject to expedited removal now, you need to be very clear with your attorney about how you entered the US, any documentation you may have. If you do not have documentation of your release from ICE custody, you need to get that. So remember, one of the first things I said you need to do to prepare for this whole nonsense that we're going through right now is you need to go ahead and get a copy of your immigration file. Typically, if you file it with USCIS, you're able to get a copy of you're able to get a copy of that ICE release as well. So it's really, really important that you do not skip that step. And it's very important that someone, as part of your preparedness planning, someone has that information. Okay. So y'all just give me 1 second because my camera is about to die and we would be out of luck if that happens. So let me go ahead and fix that. All right. Ooh, still not fixed. All right. So if you have questions, remember you can put it in the comments. And D, I see your comment. Okay. I see your comment. You got your appointment. That is amazing because there's so many people waiting for their interview and you have yours coming up and I am so happy for you. Again, guys, give me a second to figure this whole thing out. It's not working. All right. We will try a different charger to try and get this working for me today. All right. So, have you heard what the typical CR1 wait time is now for new cases? So, if you are talking about the I-130 itself, oh, we're good. We are good. It just took me time, but we're good. So if you're talking about the I-130 right now is taking about a year to a year and a half. We just had one approved that took less than a year, which is not typical, right? I believe it's like 8 months. Yeah, it took about 8 months for that to be approved. So we filed in June. So yeah, it took about 8 months for that to be approved. And then the interview is where it's going to vary. So if you are in a country that like are quick with appointments, you're most likely going to get an appointment within a year. If you're in a country like Nigeria, it's probably going to be more than a year. Okay, so it really depends on what stage you're on to know if if you're waiting on the I-130, I'll say a year to a year and a half is normal. But if you're waiting for the interview, it's really country specific and embassy specific. Okay. All right. So, okay. Yes, Bugsy. It is, if you submitted your I-130 and it's saying 22 months, it's probably going to be less than 22 months, but they have to say that because they don't want you calling them and asking them about your case. So the normal processing time is going to be longer than what you than what what it typically is. But in practice, what we're seeing with those I-130s is that it's taking about a year, um, give or take, like on either direction, right? So that's what we're seeing right now. All right. Next question. What's going to happen to the people who filed for the parole in place? Um, we don't know. Okay. So if you file for parole in place under the Biden administration, They were supposed to return your fees to you. Most people did not get their fees back before the new administration went in. So there's that. But there has been talk, because I always tell my clients, when you file anything with USCIS, you're giving them information about yourself, including where you live, who your parents are, who your kids are, right? Where you work, those type of things. So that information is with USCIS. They can choose to share that with ICE because they're under the same department, the Department of Homeland Security. So what's going to happen to the people is going to depend on um, what you know what they decide to do with those applications and what the person's status is before they filed that. So if you had TPS at the time, you'll still have TPS now. But the question is, are they going to use the information that they received from those people to then um, add them to enforcement? We don't know, but based on what we have seen, it is likely. So if anyone filed and they had they already had a removal order, they're probably going to be on a more of a priority, right? Oh wow, D, that is fast. Okay, that is good to know, and it's good to share information. Yeah, Jamaica is fast. So she was documentarily qualified in um, January 24th, and got her visa appointment scheduled by February 18th. That is fast, okay? Because there's countries where we have been documentarily qualified for a year and still waiting for an interview. And it's not because there's you know, anything wrong with the case, or it's just they have huge backlogs. So, for example, Nigeria, Pakistan is another one with a huge backlog that we're still waiting for interviews from. So that is great to know. And that's why I love it here. Y'all give me information, and the only way to get this information is by communicating. All right. So continue doing that. But congratulations, Dee. You're almost to the end. All right. All right. So let's get back to the other things. So one, the expedited removals are going to be expanded. ERO, ICE, they're going to be doing more enforcement than they were before. Okay. If you have noticed that, your news feed is full of, I supported this many people today or things like that, just know those are publicity things, right? When you want to stoke fear in people, you have to basically bombard them with images and things of the cruelty that is happening. And one of those was the ASMR that they posted on the official White House page, social media pages of someone being detained and deported. And people listening to that and sharing and happy to hear someone suffering is beyond me. I already hear that a lot in my office. I don't need to listen to it. It's not entertainment. It's not something, to be happy about that people are being treated in these ways. But that is the administration we have right now. And we need to be prepared to deal with that, right? We need to have this information to make sure that we are on top of it. And anything that happens, we are ready to take action. So not only are people expanding the expedited removal. Now, if someone was apprehended and received a notice to report to ICE for further processing, so sometimes someone comes into the US, ICE doesn't have the capacity at the moment to process them fully. they will release the person and then make an appointment for them to come into an ICE office for further processing. Those people now are subject to expedited removal. Okay. People that entered the US with parole and their parole had conditions, and they are subject to expedited removal, meaning that they were encountered within 14 days and 100 air miles of a border, or not physically present in the US for 2 years or more before an inadmissibility determination was made. So basically, again, before I said you are inadmissible to the US for these reasons, right? Before CBP said you are inadmissible to the US for these reasons. If they encounter that person and the person was then released into the US with parole, and that parole had conditions, that person is now subject to expedited removal in this expanded sense of their policy. Okay, so if someone was previously released because removal was unlikely, so sometimes you're in immigration court, the judge finds you deportable, right? Says, okay, I'm gonna give you an order of deportation, but the country that they want to deport you to says that they're not going to take you, and they can't find a third country to take you. ICE has no choice. They can't just detain you indefinitely, right? Sometimes they have to release you until they have, they are able to actually deport you to a place, right? The country that they're deporting you to has to agree to take you. So that's how this whole, like when people say, oh, they can just take you and drop you off in whatever country. No, that country has to say yes. So that's really the thing to keep in mind here, right? That country has to say yes. So they're saying if you have a deportation order and the country, which is like mostly like Cubans are not going to be deported back to Cuba, right? Because Cuba will not take them. There's certain African countries that will not take certain people. So in those situations, this policy is saying ICE needs to reevaluate whether they can deport them to a third country. Because, as many of you know, countries like Panama are willing to take people and be a third country. So that has really made it more viable for them to remove those people from the US, even if their country of origin is not willing to take them. Right? So if you're in that situation, be careful and communicate with your lawyer at all times. Know your rights, and again, be careful. But most of those people have ICE check-ins. So that's another way that they're going to be detaining people, is because people that have a deportation order, they have to check in with ICE yearly to show that they're still in the US, that they're still, maintaining a residence and all of that. So they have to check in with ICE yearly. So this reassessment can lead to those people being detained if they can find a third country to take them. Okay. And then for anyone that is not detained but reporting to ICE on a regular basis, they don't have a deportation order. Maybe they have like an immigration court case, but they're checking in with ICE. They're telling ICE that they have to basically make the review the case to see if the person is a flight risk and if they're eligible for expedited removal. This is big, right? Typically, if you are checking in with ICE and you're doing what you're supposed to do, you're able to stay and see your court case through. That may not be the case moving forward. So we really, again, not trying to scare you, but giving you information so that if you're in that situation and you have an ICE check-in, you need to check in with your lawyer first, okay? Before you go to that ICE check-in. You still have to go to the check-in. Remember that. You still have to go to the check-in, but you want to talk to your lawyer first, make sure that they are aware that you have a check-in, and that if something does happen where you're detained, they are able to file paperwork to try to get you released. Okay, you just need to be prepared. Okay. And then the last thing when it comes to this expedited removal being expanded is if you have been through immigration court and you are given withholding of removal, or you're allowed to stay in the US because they believe you will be tortured if you were to return to your home country under the conventions against torture, ERO officers, right? They have been telling them, hey, you need to review the country conditions again and to see if the person can be removed to that country because the country conditions has changed, or if that person can be removed to a third country. Again, the third country has to agree to take the person, but this is now a thing. Before, if you have withholding of removal, ICE is not, actively trying to figure out where to send you to, or if your country has changed, if the conditions have changed. But now that is a thing that we need to also worry about. All right. So Flexi D, do you have to file for I-601A waiver first before I-130? No, no. So you cannot file an I-601A waiver until your I-130 is approved. So an I-601A waiver is for people that are in the US and they either overstayed, they entered without inspection, and they need to leave the US in order to actually gain their green card. In those situations, right? I'm sorry, that was wrong. People that entered without inspection, right? Um, can't have to leave the US in order to get their green card. But in order to do that without triggering a 10-year bar, they have to get a 601A waiver. In order to apply for a 601A waiver, you need to have an I-130 approved, okay, not filed. If you just have it filed, your 601A waiver will not be processed. They will return it back to you. So you need to have your I-130 approved. You need to start the National Visa Center stage, which is just paying the fees to the National Visa Center, and you need to include evidence that you have paid that National Visa Center fee before you can then file an I-601A waiver. While your I-130 is pending, you can start preparing your I-601A waiver packet, which is what we typically do for our clients. We try to get everything ready to go so that once the I-130 is approved, we can go straight to applying for the waiver without any further delays. Okay. Is it risky right now to file a I-601A waiver? So it's going to depend. So each person's situation is different. So if the person has never had any ICE interactions, have never filed anything with USCIS, then it could be a risk because you're putting yourself out there and giving USCIS information about you and your spouse and all of that. So you need to remember, in order to file an I-601A, you need to file an I-130. So if you already filed your I-130 application, the I-601A waiver application is not going to be as risky for you as someone that has not filed anything with USCIS, has not had any interaction with immigration at all. So that's where the risk is just giving your information to USCIS. But if you already have an I-130 pending, if you already had a TPS application, if you already have like other things that you have applied for with USCIS and you've already had interactions with US immigration, either ICE or immigration court or whatever, in whatever form, the risk is much lower because either way, they already have your information, right? But that's something to talk to your lawyer about because for some clients, the risk may be too high, right? If they have any court, criminal court cases or things that we are concerned about, it may not be worth it to apply for that 601A waiver at the moment. But those are taking 3 to 4 years to be approved. So anything can happen in between that time. One thing to keep in mind is if you are picked up by ICE and you're put in immigration court proceedings, you can't file an I-601A waiver while you're in proceedings. Okay, so if you qualify for it, if you already filed the I-130 and that's already approved, you may want to just go ahead and file that 601A waiver and have it pending for the 3 years or 4 years that it takes to get that approved. Because just in case you are put in immigration court proceedings, you would already have that pending and they can't deny it once it's already pending. Okay. But if you're in immigration court proceedings and then you want to file that, you need to convince the judge to dismiss your case or to basically give you an administrative closure so that you can apply for this waiver. So it's just more steps than you really want to deal with. So again, talk to your lawyer, figure out what the best thing is for you and your family. Okay. Okay. If the sponsor stops financially supporting the immigrant, so how can immigrant complain to USCIS? There's not really a way to do that. Remember, you also, so I don't, here's the thing, right? Here's the thing when it comes to that. If the sponsor is supposed to support the immigrant, yes, USCIS can choose to do something about it. But unless the immigrant is getting some form of government assistance, USCIS can't really do anything about it, right? Because if you, the immigrant, are basically saying that you will need to rely on government assistance and you're not able to support yourself financially, you may be putting yourself at risk. If you're going through a divorce, I have seen some courts use the affidavit of support that was filed by the U.S. citizen spouse or the permanent resident spouse as a way to give spousal support. But as far as USCIS is concerned, they're not really going to do anything about it unless the immigrant is actually on some form of government assistance. Because the whole point of the affidavit of support is for you not to need government assistance. So unless that is the case, but then just know that also affects your ability to ever become a citizen because there's certain things that a permanent resident cannot qualify for. So you need to talk to, there's a lot to it. So you need to be careful what you're doing and not just, I know sometimes we want to like, oh, this person is doing us wrong, but you don't want to do something to spite one person and then end up hurting yourself. Okay. You want to make sure that whatever you're doing is not going to then affect your permanent residency and your ability to ever become a citizen. Okay. Like I said, typically USS will not do anything about it. However, if it's like your spouse, that's the person that did the affidavit of support, and you're going through a divorce judge may take that into consideration in deciding whether the sponsor is supposed to pay spousal support. But that's really as far as I've seen that go. Okay. All right. Again, generally not, a good idea to give USCIS more information about you than is necessary. That's all I'm going to say on that. Okay. All right. So if you have any other questions, please go ahead and put them in the comments. I don't see any new questions, so I'm going to go ahead and just recap what we have talked about so far. So all the changes, it's still coming in. We're going to be getting new policy changes, new things every single week. So we need to be um, very aware of that, and that's why I do these lives and I do my Tuesday videos to give you as much update as possible. I try not to like bombard you with information, but when I'm bombarded with new information, I want to make sure that you have it as well. Okay. All right. My brother came to the States without inspection. Now he's married to a US citizen. What happens now under this Trump administration? So if he entered the US without inspection and he was not given parole or anything like that, he will, being married to a US citizen does not fix his status. Okay. The question that I typically would ask if this was a consultation is like, did they have any interactions with CBP? Was he detained? Was he released from detention? And if he was released from detention, was he given parole or was he released on an order of deportation, released on his own recognizance, right? So that is what's gonna matter. If he was released on parole and the parole is under like humanitarian parole provisions, then he will be able to apply for a green card through the spouse. But if he was released on his own recognizance, he will not be able to apply for a green card in the US. He can apply for an I-130. His spouse can apply for an I-130 for him. Once that is approved, he can then file an I-601A waiver. Again, these things take time, and dependent on when he entered, if he had ICE interactions, if he has inadmissibility determination, all those things are going to matter, and whether or not he is subject to expedited removal. So needs to be careful, needs to know his rights, and needs to get a consultation with an immigration lawyer as soon as possible to know what he can qualify for. But if he did not have parole, he would not be able to adjust his status and get a green card from within the US. He will have to eventually apply for a 601A waiver if he is not subject to ICE enforcement. Okay, if ICE does not target him, then he would be able to do the I-130 and the I-601A waiver. But again, he needs like a more detailed consultation. He needs to do that because that's the only way he can actually know what he could do. Okay. I've had people come to me and they're like, oh, I wasn't given any documents. I'm not sure if I was paroled, if I was, what happened. And what we have done is get their immigration file from USCIS. And guess what was in there? They had parole and they did not know it, right? They didn't have the documentation. And we were able to look through their A file and see that they did have parole. Now we're going to be starting their green card application process. So it's really, like I said, it's really, really important to get a copy of your file, especially if you're not sure what happened when you were detained and all of those things. So you know what you can qualify for. All right. Let's see if I missed anything. So Sabrina, if you're still on, I still don't fully understand your question. So maybe send me a DM. You're watching on Instagram, so feel free to send me a DM with like more information so that I can actually answer your question. But I'm still not sure what you're trying to say. Okay. All right, guys. So quick recap. TPS for Venezuela and Haiti are vacated. So once the TPS you have right now expires, that's it. You're not able to renew your TPS. So Unfortunately, that is where we are right now. Any application filed by people that entered under a Biden administration parole program, so think Haiti, Venezuela, Cuba, Nicaragua, Ukraine, right? All those countries, if you are, if you have any application pending, for example, TPS, green card application through a spouse, whatever additional applications you're filing for in the US, those are going to be put on hold. Okay. And this includes the United for Ukraine applications as well. So those applications are going to be put on hold while the Trump administration tries to figure out if everyone committed fraud instead of actually processing the application and making that determination as part of the processing of the application, which is what typically happens. Okay. Like when you file an application with USCIS, let's say you're applying for a green card, they're going to look at how you entered the US to make sure you actually like met that requirement before they approve your green card. So it's not as if these fraud inquiries are not happening, right? They are part of the process. It's part of the process to review how the person got their parole and how they entered the US before approving their green card application or their TPS and all those things. But alas, they're just putting a hold on it, making the process take longer than it needs to be. There's going to be an expansion of the expedited removal who falls under it. So anyone that's had ICE interactions that was released from ICE custody, that has withholding of removal, that has to check in with ICE, all those cases are being reviewed to see if they can be redetained and if they can be deported back to their home country or to a third country like Panama, because Panama is just taking people now. All right. Next question. Could you explain if I can do a K3 visa process? My US citizen spouse filed for me June 2024. Because we didn't have much evidence since our marriage was a few months old, please can I add unsolicited evidence on our USCIS account online? So I'll take your first question. Can you file a K3 visa application? Yes, you can. But since your application has been pending since June 2024, you may not get a decision on that K3. So we had a case where we filed in June of 2024 with the I-130, and then soon after we filed the K3. And the I-130 is now approved, and the K3 is just out there, right? So you may be in a situation where you can file it. Can you file it? Yes, you can. But what we have found in practice is it's good to file it close to the time that you file your I-130 because it can help speed up the I-130 process because they rather you finish your whole process outside of the US and come in with an immigrant visa than have you come here on a temporary and then apply for a green card and all of that. So can you do it? Yes, absolutely, you can still file the K3. Can you add unsolicited evidence? Yes, there's a button there on the USCIS account where you can upload unsolicited evidence. Do they look at it? Typically, if they have not done a final review for your case, they're not going to tell you, oh, yes, we received your unsolicited evidence. But what I have found is that when we do upload that unsolicited evidence, it does help once the officer gets to the case. The evidence is already in there, so they don't need to request it from you. So that's where that would be helpful, is if you didn't have a lot of evidence and now you do, you can upload it so that when the officer gets to the case and is reviewing, they already see that evidence and then they can decide whether they need more than that or not. But if there's no evidence and they want more, they will send you a request for evidence. So it doesn't hurt your case. It typically doesn't hurt your case to upload more evidence of your relationship. They want evidence of your relationship. Okay. All right. When you receive your 10-year green card, June 2023, when do you think is best to apply for naturalization? There's not really a best time to apply for naturalization. It's just a matter of when you qualify to apply for naturalization. That's more the question I think you're trying to ask is when should you, when do you qualify? So if you got your green card through marriage and your spouse is a US citizen, you can apply for citizenship in 3 years. If your spouse is not a US citizen, or they haven't been a US citizen for 3 years, when your 3 years comes up, you can apply in 5 years, right? So if you didn't get your green card through marriage, then it's 5 years. So there's not really a good time, right? Or best. It's just when do you qualify, and just making sure that there's nothing in your history that can affect your ability to apply for citizenship. So the biggest thing is criminal records. Stay away from that. Traveling outside of the U.S. for extended periods of time, don't do that, because they can then question whether you actually meant to be a resident or not. So just make sure you're not doing stuff that will make the US government question whether you want to actually be a US resident. All right. So 3 years if you're married to a US citizen, 5 years if you're not. Okay. And 5 years if you don't want to file based on your marriage to a US citizen. Okay. If you are filing under the 3 years for citizenship, you do need to show that you and your spouse are still together, you're still building a life together. So if you get divorced, you no longer qualify for the 3 years. Okay. So keep that in mind as well. All right. So remember, questions, put them in the comments. One thing that I do want to bring to your attention is that your cases, unfortunately, if this administration keeps going the way they are, cases are going to take longer. Okay. And it will have absolutely nothing to do with your particular case. It's going to take longer. Let me tell you why. They are firing people. So, for example, they fired a bunch of immigration judges. Remember, immigration court is very backed up. We have too many cases pending and not enough judges. And guess what they did? They fired some more judges, right? Reducing the number of judges that can actually hear the cases. Also, we have people waiting for their cases that they appealed to the Board of Immigration Appeals, and it is taking years. Okay. I have an appeal that we filed in 2020, and the Board of Immigration Appeals has not even gotten to the case yet. Okay. They have not even made a decision on the case yet since 2020. And guess what they did this week? Fired a bunch of judges from the Board of Immigration Appeals, because why not make the process take longer than it needs to? So instead of adding more judges and more appeals judges to make the process go faster, they're firing judges, and that's going to make the process slow down. And we believe that they may also be firing some USCIS officers. So USCIS cases may also have backlogs more than they already are. So my expectation is that a lot of the processing times are going to increase exponentially. So it's going to take longer. And as much as the administration talks about legal immigration and then people doing it the right way and all those things, they're making it harder for people to do those things, right? By firing USCIS officers that then make those determinations of whether an I-130 or a fiancé visa application can be approved and sent over to the embassy and all those things. Those are going to slow down too. So we're going to be back where we were before, where things were taking forever. But this time it's not going to be because of COVID. It's going to be because of people being fired at USCIS and immigration courts and all of that. So again, not to depress you, but to give you information and give you kind of so that you are not in a situation where you are, thinking that the reason that your case is not moving fast enough, the reason that you're not already scheduled for an interview is because there's something wrong with your case. It could just be that there's not enough officers to review your case, or if you are part of any of the Biden parole programs, it could just be that pause on those applications that's affecting your case. So before you think it's you, before you freak out and think it's your case, it could just be the system not working properly and working exactly as the administration intends it to work. But on our end, we'll continue fighting, right? So we will continue fighting and continue following the policies as they come. And, I remember someone saying you're supposed to follow the US laws. Well, yes, right now they're changing rapidly. And my job for my clients is basically to follow every single change and make sure that their applications are being filed according to the current immigration laws, right? Because as they're changing, we have to adapt as immigration lawyers and figure out the best way to work within the system that we have. And that makes me want to do these lives and post videos as much as possible, because I know these people out there that can't afford my services, and I don't want you filing things that you no longer qualify for because there's a change in the administration, or you not knowing what you qualify for, right? I want to give you as much information as possible because I know I'm already doing that for my clients, right? So they don't have to kind of keep up with everything that's going on, because I send them an email. I let them know, okay, this does not affect your case. You're good. Everything is fine. We're just waiting, right? They get that reassurance from me. And I know some of you out there are not in a position to get that reassurance. So I want to give you as much information as I possibly can, and make sure that you don't feel like you're alone. You can always come here and ask questions, right? Should we apply for premium processing? So when it comes to, unfortunately, when it comes to family-based applications, I know you say you're filing, your spouse is a U.S. citizen filing for you. When it comes to those applications, there is no premium processing. The premium processing is literally specifically for employment-based visas. It would be nice if there was premium processing for marriage-based applications for clients that can afford it. That would definitely speed up the process, but that is just not available for those applications. Sorry. All right. We filed for a spousal visa last year, April, as permanent resident, but became a citizen last November. I saw a USCIS February bulletin that they are current for July 2024. We are yet to get a feedback. So let me make sure, because there's two things, right? If your case is with USCIS and it hasn't been approved, so if your I-130 is with USCIS and it hasn't been approved yet, the visa bulletin does not affect your case yet, right? Now, if your case is with the National Visa Center and you're waiting for your case to be documentarily qualified, or you're waiting to get that invoice and case number to start the process of doing your DS-260, The visa bulletin only helps if you are a permanent resident, right? But here's the thing. As a US citizen, the visa bulletin no longer applies to you. So you need to inform the National Visa Center that you are now a US citizen so that they can move your spouse's category from the spouse of a permanent resident to the spouse of a US citizen. Okay? Because they have two separate processing times, and the embassy handles those cases differently. They prioritize the spouses of US citizens over the spouses of permanent residents. So if you have not updated USCIS that you are now a citizen, or you have not updated the National Visa Center that you are now a citizen, then that's just what it's going to be. But the main thing is it depends on where your case is at. So if your case is with USCIS, you need to look at the USCIS processing times, not the National Visa Center visa bulletin. So, okay, so the case is at USCIS, the National Visa Center, the visa bulletin does not matter at this moment. Okay, the visa bulletin only matters once your I-130 is approved. If the I-130 is not approved yet, do not look at the visa bulletin, okay? Because it's just going to confuse you. So that priority date for July 2024 is for people that already had their I-130s approved, right? They can start processing their visas. But if your I-130 is still pending, you can't process any visa, which is why you would not get anything from the National Visa Center. But if you have updated USCIS that you're now a citizen with a copy of your naturalization certificate, they're just going to process your application, okay? But typically, they're not going to send you anything to say, yes, we received your documents, right? If you have a USCIS online account, I typically do those updates through that account so that I can have like documented evidence of when we submitted it and all of that. But yeah, just making sure I got everyone. How the facilitation return works. Again, Sabrina, not sure what you mean by facilitation. You mean when the person is being sent back to their home country, how that works? Just let me know if that's what you mean, because I'm not sure. Okay. All right. So those were some great questions, guys. Great questions as always. My job here is to get you information. Okay, that's my job, not to scare you, but to make sure that you are informed and you know how to move in these uncertain times. Okay, so if you are watching this on the replay and you have questions, put them in the comments. If you are in a position where you want to get a detailed consultation from me and actually have a case status evaluation, or you just need to know what you qualify for, go ahead and schedule a strategy session with me. You can also, I now opened up a separate appointment thing for a detailed consultation. So the strategy session is more of a let's figure out, could you qualify for something? And then the detailed consultation is a deeper dive into your whole history, right? We're looking at documents. We're doing a full evaluation. So go ahead, figure out which one you need and schedule that so that we can help you as much as possible. And if you want to schedule either the strategy session or the detailed consultation, you can do that by going to my website, lilylegal.com/contact us, or just go to lilylegal.com, click on contact us, and you will see both of those on there. And you can select the one that works best for you, okay? You'll see what times I'm available. for those different appointments and schedule it. All right. So I don't see any other questions. Thank you all so much for joining me. I will be putting out a video on Tuesday that basically dives deeper into all the new changes and just gives you more detail, right? With the live, we try to talk about everything, but with this, I'm going to focus more on um, giving you as much detail and making it clear who it applies to and all of that. So feel free to watch that. And then next week, Friday, we are doing Q&A. Okay, so bring your questions to that. If you do not feel comfortable asking me questions on here, I try not to post. So typically I can like show the question. I try not to show those anymore because I want people to have their privacy when they're asking questions. But just know if you don't feel comfortable asking questions on YouTube, Instagram, Facebook, send me a DM with your question before Friday. Okay? Send me a DM with your question before Friday, and I will cover it on Friday. All right, guys. Thank y'all so much for joining me. As always, I am Lillian Chukurama, US based immigration lawyer, and I will continue to help my clients get green cards and citizenships using the current US immigration law system. Bye, guys.